All right, we're going to go on the record and cause number 2026 CR007561, State versus Amanda Sabrina Morehouse. Can I have parties approach and announce for the record?
Yes, yes. Ready to see. Warren Wolf, Ms. Morehouse.
And probation, this is an application. Hello, good morning.
Good morning.
Are you Ms. Morehouse?
Yes, ma'am, I am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Morehouse, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am, I sure did.
Did you review the true bill of indictment with your attorney?
You're holding right there.
It's the document that tells you what you're charged with.
Yes, ma'am, I did review it, but I did have a quick, and
Yes.
when I talked to, they did not find that on my person in front of the video, and that's what I explained to him.
All right, so let me explain something to you. Number one, if you want a jury trial, I will give you your jury trial. Number two, what ends up happening when you enter a plea, the state usually doesn't present any witnesses. They just present police reports. I will review the police report. And then what I can tell you, if from reviewing the police report, if it doesn't establish your...
All right, let's pause for a second. That was one of the most important statements we've heard so far. Judge Boyd just reminded Ms. Morehouse of the foundation of the American justice system. The state must prove every element of the charge beyond a reasonable doubt. If the evidence falls short of that standard, the court cannot find the defendant guilty. That's not the judge taking anyone's side. That's the law. Now, pay close attention to what happens next. Judge Boyd begins using hypothetical examples to explain how the law applies. Experienced judges often do this to make sure everyone understands the legal issues before making a decision. So here's my question for you. Based on what you've seen so far, do you think the prosecution has enough evidence to meet that burden? Or do you think the defense has a real opportunity to create reasonable doubt? Let me know what you think in the comments. This hearing is just getting started.
Beyond a reasonable doubt, then I'm going to find you not guilty. I'm going to find that the state didn't prove its case. However, sometimes people don't understand with possessions of drugs and when you're being accused of possession, hypothetically, because I don't know anything about your case yet because I haven't read anything. But if you're in a vehicle, I'm just telling you hypothetically, if you're in a vehicle, it's you and it's three other people and there are drugs in the vehicle, everybody can be charged with possession of the drugs. What it will depend on is it within your reach? Because it's just all about care, custody, and control. If you're riding on a bicycle and the police pull you over and there's something in a backpack on a bicycle and you were riding that bicycle, you're in possession. Now, if you're saying, I didn't know these drugs were in this backpack, this is not my backpack, that's something for a jury trial. You understand? So if you want a trial, I will give you a trial. If you do not want a trial, then we'll continue with the plea. I'm going to read everything. I'm going to explain to you your rights, and then I'll make a decision on whether or not the state has presented sufficient evidence to find you guilty beyond a reasonable doubt. You understand?
Yes, ma'am.
Do you have any questions about anything?
No, ma'am.
Okay.
Thank you.
You're welcome. Oh, you're welcome. Please ask questions about anything that we're going on here today, because this is the most important thing in your life right now, okay?
Mhm.
All right, so the indictment tells you what you're charged with. Did you have a chance to review that with your attorney?
Yes, sir.
All right, did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of this indictment?
Yes.
State, are you proceeding on the indictment as she has received it?
Yes, that's as she was.
Ms. Morehouse, did you review the court admonishments? Is this
No,
document that tells you what your rights are?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
All right, I'm going to go over your rights with you. If there's something you don't understand, let me know.
Thank you.
You're welcome. Okay, so you're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to...
All right, here's the reality of the situation. Judge Boyd has just explained the possible punishment for this third-degree felony. If convicted, the sentence could range from 2 to 10 years in prison, along with a fine of up to $10,000. This isn't just courtroom procedure. It's one of the judge's most important responsibilities. Before accepting a plea, the court must make sure the defendant understands exactly what they're facing and the legal consequences of every decision they make. Notice how carefully Judge Boyd explains each point. She isn't rushing through the process. She's making sure the record clearly shows that Miss Morehouse understands her rights and the possible outcomes. That attention to detail protects both the defendant and the integrity of the court. What do you think so far? Would you want every judge to take this much time explaining the law, or should hearings move more quickly? Share your thoughts below.
10 years in prison and up to a $10,000 fine. If you have an agreement with the state, I don't have to follow your agreement. If I don't follow your agreement and give you more than what you've agreed to, the fact that you entered a plea will not be used against you. You can withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent. By entering this plea, the state is not going to call any witnesses. So there's nobody for you to cross-examine, and you're giving up all of these rights, the right to trial, the right to remain silent. Do you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
yes,
Ms. Morehouse, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than your plea bargain agreement?
no,
Are you satisfied with the way you've been represented?
no. To the best of my ability.
All right.
I mean, to the best of the case ability.
Okay. Do you understand if you're not a U.S. citizen, you will be deported, denied naturalization, and reentry? Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 3 years in the prison. There's $1,000 fine that's to be probated. So what that means is if you successfully complete your probation, you don't have to pay the $1,000. If you are unsuccessful in the completion of your probation, you may have to pay the $1,000. Do you understand?
Yes, ma'am.
And the court is and the state is recommending community supervision. Do you understand that as your plea?
Yes, ma'am.
State defense?
That is a plea, Judge.
it is, Judge. There's also Ms. Morehouse wanted to apply for deferred, but that's outside the agreement.
Okay, there are no boxes checked for deferred.
Judge, the state did that for community supervision.
I haven't had been in trouble.
Just wait,
since
just wait.
16.
All right, so here's the thing. Your agreement is not on an application for deferred adjudication. Now, if the state wishes to change their agreement and let you apply for deferred adjudication but be opposed to it, they can do that. But according to this plea bargain agreement, there is no application for deferred adjudication. Do you understand?
We discussed
We discussed it.
that to permit her to apply, that you would let the judge decide that, but you were going to agree to the probation.
We were gonna agree to community supervision.
Right.
Just please step back for a moment.
Sure. All right, y'all step back. Destiny Jackson.
You get my glasses fixed, Judge.
Well,
New prescription time.
they keep wanting to do a line for me, and I'm absolutely not, because I only need my glasses for distance, not for reading. And so the ophthalmologist said, oh, when you are tired of taking your glasses on and off, you'll get the line. I'm like, I will never be tired of doing that, so it won't be happening. All right. Good morning. All right, so what do you have in your mouth?
Cough drop.
Oh, cough drop? Okay, I'll allow it. All right, today's plea deadline date.
We've conferred, we don't have an agreement right now, Judge, we can just put it on a trial document.
All right, Ms. Ferguson. On this case, if you'll set this for August 17th for jury trial.
Yes.
All right, your plea deadline date it's expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you'll have to plead open to the court. If I could get an acknowledgement of discovery, please.
Yes, Your Honor.
All right, thank you.
Thank you.
You're welcome.
All
All right, thank you. All right, we are back on the record. In 2026 CR 007561, State versus Amanda Morehouse. Could parties re-announce for the record, please?
Yes, Judge. Brandon Blair with the state.
Warren Wolf or Amanda.
All right, so with regards to the plea bargain agreement, there is no application for deferred adjudication in the plea bargain agreement. Is that correct?
Correct.
Right. Judge, the agreement was we were going to agree on probation, but we were
Permitted.
going to apply for deferred and the state would be opposed to it.
All right, that's not in your plea paperwork.
Well, it's amended. I think we've got this squared away,
Okay.
Judge.
All right, so with regards to your plea bargain agreement, you're applying for deferred adjudication. The state is opposed to your deferred adjudication. Do you understand?
They're not agreed to.
Then the state doesn't want to agree, so that also depends on,
I'm sorry, you're gonna have to speak up.
that also depends on you. If you
Yes,
decide,
I'll make the decision.
and I,
Do you understand that as your plea?
yes, ma'am.
Now, let me
I've been in trouble.
All right, let me explain to you about deferred adjudication. With a deferred adjudication, if I were to grant it,
This is a critical moment in the hearing. Judge Boyd is explaining deferred adjudication, and it's something many people misunderstand. In simple terms, deferred adjudication gives a defendant the opportunity to successfully complete probation without receiving a formal conviction. On paper, that sounds like an excellent outcome. But there's an important catch. If the defendant violates the conditions of that probation, the judge can impose any sentence allowed by law, including the maximum penalty. That's exactly why Judge Boyd is taking the time to explain every detail. She wants to make sure Miss Morehouse fully understands both the opportunity and the risk before making her decision. These conversations may seem technical, but they often become some of the most important moments in a criminal case. So let me ask you this. If you had the chance to accept deferred adjudication, knowing that a mistake could expose you to the maximum sentence, would you take that opportunity? Let me know in the comments.
for any reason your deferred adjudication were revoked, the court could grant the motion and sentence you up to 10 years in the prison. Do you understand?
Yes, I do.
With regular probation, for example, according to this plea, the state is recommending community supervision and they're asking that your punishment be assessed at 3 years in prison. So under that scenario, if I were to give you community supervision or regular probation, if for any reason you were revoked, the court could only sentence you up to 3 years. With the deferred, if you're revoked, you could be sentenced up to 10 years. Do you understand?
I do understand.
And with a deferred adjudication, if you successfully complete it, it will be on your record, but it won't show up as a conviction. Do you understand?
That's what I want.
All right. So does everybody understand that to be the plea?
That's what I'm saying, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years, 100 hours of community service restitution, that's working somewhere for free, the MRT, regular UAs, and a mental health caseload. Did you understand those were recommendations from the state and I do not have to follow those recommendations?
Yes, ma'am. I do understand.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Judge, we offered you state exhibit number 1, including all of its attachments.
No objection.
All right. State before you leave, is there a reason you're objecting to deferred?
Judge, it looks like the defendant was already on deferred for theft property, 50 to 500. We received deferred adjudication on that. It was extended a couple of times. That ultimately ended in 20 days in Bear County Jail. Further, she does have a conviction for resisting arrest.
Okay, all right, thank you.
Of course, sir.
All right, Ms. Morehouse, did you review the waiver and stipulations with your attorney?
Yes, ma'am, but I
Just
just,
wait, you can just listen to what the judge says.
All right. Again, do you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Do you understand?
yes, ma'am.
Do you understand that today the state is presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court would defer finding of guilt as you applied for deferred adjudication. Do you wish to proceed with sentencing? Or are you asking for a PSI?
We can proceed.
All right, so first things first. 1, I reviewed everything. The evidence is sufficient. So the state has proved their case beyond a reasonable doubt, according to the stipulations. Now, with regards to her criminal history, the state has recited her criminal history. Is that the correct criminal history?
I was not representing her on those matters. I've discussed some issues about her past. I don't know if she understood at the time what was going on.
For what, the cases that her criminal history?
Yes. And I'm not sure of her mental status at those times. As far as today is concerned, she understands what's going on. And she would like to talk to the court about her history and why she why she's asking for.
Sure.
I just heard the state say something about theft. I don't have any thefts on my background. And I haven't been in the state of Texas. I've been back to state of Texas for 7 months.
Where were you before?
I was in state of North Carolina. I had a.
I'm sorry, where?
I was in state of North Carolina for the
Oh,
last,
excuse me, everyone, please whisper.
for the last 11 years up until this year, up into the state of North Carolina with the job. So I don't know
Here's the thing.
where they come see something about that.
So were you in Bear County on April 23rd, 2026? Because that's the date of this offense.
But it was a trespass, no trespass.
No. It was not. Let me just tell you what the facts of this case are. You were in a park. The police received calls that somebody had a lighter trying to light things in the park. That was you.
Just listen.
And then they brought you over to search you. They had a female officer.
Now the hearing shifts in an important way. Up until this point, Judge Boyd has been explaining legal principles and discussing possible outcomes. But now she's turning her attention to the actual facts of the case. That's a significant change. Instead of talking about legal concepts, she's reviewing the evidence and comparing it to what the defendant has told the court. Notice how carefully Judge Boyd walks through each detail. She's making sure everyone understands exactly what information is before the court. Cases often turn on facts like these. Small differences in testimony, physical evidence, or video footage can completely change how a case is viewed. At this stage, credibility becomes extremely important. Do you think the evidence supports the defendant's version of events, or do you think the facts are pointing in a different direction? I'd love to
do
hear
that
your
because
opinion.
they need female officers to search females. They saw you drop baggie on the ground. That's where the possession comes in.
That's what's in the report.
So that's what's in the police report. So let's start here. Why were you in the park with a lighter attempting to light the grass?
It was not, I had a cigarette in my hand. It was the cigarette that I had in my hand. When the officer got there, I had no cigarette in my hand. I had just a lighter in my hand.
Mhm.
And the female officer searched me.
Well,
When they
no, let me
walked,
just tell you, the police received a phone call, and the call stated that you were attempting to light a flame in the open field using a lighter. And it's April, so I'm assuming Texas, San Antonio, it's dry. You can start a major fire. So what were you doing in a field at that time?
I was walking on the sidewalk I wasn't even in the park, I was on the sidewalk. And I sat down on the sidewalk on the curb, and I sat there and I had a cigarette in my hand.
No, that's not what this says. They say you were in the field.
Well, we looked at the video and you were
I
not
was
on the,
not in the field at the park, I was on the sidewalk, that's what
Oh,
they.
is there a video?
yes. And we've looked at it. And you were not on the sidewalk.
I was on the sidewalk.
When they
The
approached
field.
you.
Yes, I was. I was on the sidewalk.
After that, after you left
I
the
was on the
sidewalk,
sidewalk.
you were back in the middle of it.
I promise to God, I was on the sidewalk.
Oh, you know what? If you want me to view the video, I'll view the video.
I was on the sidewalk when
All right,
they went, the office.
State.
Give me a vote, Judge.
sure. Defense, the state is going to be offering the video into evidence as state exhibit number 1. Any objection?
Judge, they've tendered it to me. I just.
I'm sorry, Mr. Prater,
Yes, Judge.
because because the stipulations are state exhibit 1 and attachments, do you want to make that state exhibit A?
That's perfectly fine.
All right, so the state is going to offer state exhibit A into evidence. Any objection?
No.
And I will review it. Let's play it. Here's the thing. Sometimes, well, not sometimes, you really should listen to your attorney, okay? All right, while the state is pulling that, have you ever had any type of mental health diagnosis? You've never been prescribed any type of medications? I need yes or no.
Not for mental health, no.
Oh, what, have you
I have
ever?
scoliosis.
Okay. Do you have any family here in San Antonio, any support system?
Not here in San Antonio, all my family's up north,
All your family is where?
up north.
Okay.
The public shakes of the court, Judge.
Yes. Granted. And this is State's Exhibit A, correct?
Yes.
All right, thank you. All right, so Ms. Morehouse, from watching the video, you're not on the sidewalk, you're in the park. You're not supposed to be in there, and the problem is during these months, lighting fires on grass that cause a whole host of problems. You can't do that. So I'm telling you what the stipulated evidence is. I'm telling you what I viewed in the video. If you want to withdraw your plea, you're more than welcome to withdraw your plea. We'll send you back over to the Bexar County Jail, have you dressed, and we can start a jury trial today. Do you understand? You need to speak up.
Yes, ma'am.
All right, so how often have you been using before you were taken into custody?
I haven't been using,
All right, so this is what I'm gonna tell you. I'm gonna grant your application. If you end up testing positive, that's a violation of your probation and a warrant is going to be issued for your arrest. Do you understand? So I go back to my question. How often before you were placed in custody were you using drugs?
You gotta speak out.
I wasn't using for oxygen.
All right. Do you have any children?
They're adults.
Do you have any grandchildren?
Yeah,
I'm sorry,
yes, ma'am.
what are their ages?
4 and 5.
And do they live in San Antonio?
They don't.
When's the last time you had employment?
3 months ago,
Doing what?
TJ Maxx warehouse.
All right, this is what the court is going to do. The court is going to find you guilty. The court will sentence you to $1,000 fine that will be probated. Regular reporting by Zoom or in person. Excuse me, no hugging up in the courtroom. Save that for outside on your own time. Regular reporting by Zoom or in person. Random UAs. Monthly. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Field visits 1 time per month for 4 months. TAP evaluation out of custody. 100 hours of community service restitution. I'm gonna order the MR. Well, you can do a MIC evaluation. And that can be done out of custody. And the 100 hours of community service restitution, I'm gonna order the MRT. Once that's completed, the community service hours will be deemed satisfied. The court will sentence you to 3 years in prison, suspended and probated for 4 years. And there is to be no residing in households with minors. No unsupervised contact with minors. And there's to be no contact with Palo Alto Park. Probation, is there anything else?
No, ma'am, I believe you've got it all.
Thank you. Did you review the document entitled Trial Court Certification of, she hasn't signed this.
What you do?
No, she signed in my spot.
Yes.
That's okay.
Well, she has aspirations.
Uh-huh.
You missed this one.
All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Santiago Hernandez.
May we approach, Judge?
Yes. All right. Today is plea deadline date.
Judge, we've accepted the state offered pretrial diversion today, and we're going to get that application in today.
All right, I need a PTD date.
And to be fair to the state, I presented them information that changed their offer, so it's not that they waited, it was me.
All right, thank you.
I can do the 31st.
All right, once you sign the reset form, you're excused. Make sure you follow through on everything that's asked of you. Do you understand? Is he a Spanish
Yes.
speaker?
Yes,
All right,
I
we
know.
need an
I
interpreter.
know, that's my fault, Judge, I'm
Thank
sorry.
you.
Lucia.
Call for an interpreter, please. Nicholas Morris.
May we approach, Judge?
Yes. Spanish speaker?
No, no. Swahili. Nicholas is talented, he might, but he does know English very well.
Okay, awesome. Good morning. How are you doing today? All right. So what is happening? Today is supposed to be disposition day.
Judge, we have accepted an offer that requires us to plea in a misdemeanor court that is closed today. He's set on the 4th there.
Okay,
And that will resolve everything. The case here will be completely disposed of without a plea.
all right. So you're saying he's set on August 4th?
Yes, Judge.
All right. Let me see something. All right, Norman, recall this for August 4th
Thank you, Judge.
and go to misdemeanor court first. You too.
May we be excused once we've signed our forms, Judge?
Yes.
Thank you.
All right, who's next?
On page 6, fifth one down, Pamela Travieso.
Pamela.
Okay. Yeah,
So she's got 3 cases that are at large that are coming down the pike. We're gonna try to work out a deal where all of them are gonna be disposed of. I've already spoken to the prosecutor and they're amended to that. But we're still waiting to see on the 3 cases. So we're needing another reset and orders because all these cases will be disposed of together.
so how much time do y'all need?
At the at large, I'm thinking 30 days.
All right, Ms. Ferguson, I need a 30-day reset. And you can just say it's for discovery. When?
Got it.
All right, August 31st. Once you sign the reset form, you're excused.
Thank you, Judge.
I thank you.
I
Good
appreciate
seeing you.
Go ahead and have a seat. I gotta take the reset.
Who's next?
Page 4, first one, Donnell Smith. She left to post.
Janelle Smith? It's like I just saw you. Yeah, your client was back there hugged up with somebody. Okay, so on this case, we were here for discovery, and I know you were recently appointed.
I was appointed at the last setting.
Yes.
And I just got access to Discovery within the past 5 days. I've got to get it all downloaded, make sure I have everything, and then go through it and get with my client. So.
All right, so
I need some time.
we are going to recall it for 45 days. So that'll give your attorney a chance to have discovery.
Yes, ma'am.
And are you employed?
Yes, ma'am.
Right. So you can appear by Zoom because it's a discovery date and your attorney will give you the Zoom link. But when you appear by Zoom, you have to be dressed appropriately, okay?
Yes, ma'am.
And not hugged up. All right, Ms. Ferguson, I need a 45-day reset.
September 14th.
All right, so we'll be back on September 14th. Once you sign the reset form, you're excused.
The interpreter's here for us, Jane.
All right, if they'll come up, please.
Usually writes it down.
And what is your client's name? I'm trying to find him on the docket.
Santiago
Santiago?
Hernandez.
Okay,
And some things too, Judge.
thank you. Hello. Okay, now I know that you don't say, one thing I do know. I know that you don't say hello in Spanish. That's not Spanish, is it?
It's not Spanish.
Deputy Laura? Is hello Spanish?
No.
You gotta use the interpreter. Or either we won't use the interpreter. Do you need the interpreter?
Yes,
Okay. That's Spanish.
it's business partner.
All right, so you're gonna come back on August 31st. My understanding there's an agreement for a pretrial diversion. You need to make sure that you follow through on whatever is in the contract. And if you have a question about what's in the contract, you need to speak to your attorney. Do you understand?
Yes.
All right, once you sign the reset form, you're excused.
Okay.
All right.
Yeah.
Good night.
Thank you, Judge.
Thank you. All right, who's next?
Page 4, fourth from the bottom, Matthew Barber.
Matthew Barber. Yes. All right, how are you doing?
Pretty good.
We're dressing appropriately for court.
I've tried to commit in the.
So today is your plea deadline date.
Okay, I thought it was discovery.
Because last time y'all were here, an offer was tendered. But so do y'all need more time?
We do, Your Honor. I'm sorry. I've been
No
so
problem.
busy.
Okay.
Thank you.
All right. This will be your final plea deadline date. Norma, recall this in 30 days for final plea deadline date.
Okay,
All right, so it's August 31st. At that time, you'll need to let me know whether or not you all have reached an agreement. If you have not, your next court date is going to be a jury trial date. You understand?
all right.
And you need to make sure you're on time for court. It's at 9 a.m.
Thank
Okay.
you, Your Honor.
All right, thank you.
Appreciate it.
You're
Bye-bye.
welcome. All right, Kit Kilpatrick. Hi, where's Kit Kilpatrick?
She is in the Gillespie County calaboose.
Oh, okay.
She was here, Judge, she was here the last day Mr. Smith was here.
Yeah.
And she had an MTR or motion to enter adjudication in Gillespie County and a new case up there.
Yes.
I've been in touch with her attorney. They have made an offer deferred on the new case. They're going to reduce it keep her on deferred on the other case, on their MTR case. And they want her to go to safety.
Okay.
The rec here was for SATF, but I talked to my client yesterday. She's willing to go to safety, wants to go. And so,
Probation, can you come forward? Stay on Kit Kilpatrick. Can you all come forward, please?
yes, it's kind of a logistics question right now. Do we want to let her go ahead and get sentenced up there?
Yes. So on this case, she has a case out of Gillespie and we released her so she can go to Gillespie. He says on the MTR in Gillespie, they are denying the motion and alternate amending for safety. Here, probation's recommendation was SATF. So are you all okay with withdrawing this motion and just alternating amending conditions for safety? Because the new number 1 is a possession case out of Gillespie County. So she has 2 violations.
And Judge, the reasoning for recommending SATF is that we start at the lowest modality.
Mhm.
And then we have some place to go after that. Whereas if we start with SafeP, it's difficult if they relapse to then get them into SATF and get them back through all of that. That's the only reason. But if Gillespie's, if that's the only way they're going to continue her, that's fine. Since she's living here, she can finish they can do the packet, they can do the referrals and everything, and then we can do the aftercare portion of it with our SafeP aftercare unit.
Judge, I would just need the order from up there then, just because she has two prior, she's on deferred in like multiple counties, so the only reason I'm even agreeing to this is because that's what they're saying up there, but yes, I need proof.
Okay, all right, so when do you think you'll be able to get proof of that?
They want proof, I guess, call the DA and ask her.
I'm not, I'm thinking your client will enter their plea and then I can get the judge.
Oh, that's fine.
He's like, oh, I don't want.
Yeah, that's the proof you want. I'll tell them to go ahead and get it done.
Okay,
Yeah,
okay.
fine.
All right, so y'all want to recall this in, what, 2 weeks, 3 weeks?
I think it should be, I want to say that her attorney told me her next setting is in September. They may be able to expedite that, but they don't do their docket like we do with.
All right,
Where they have dockets every day, I don't think.
September, that's a long,
And if you would like, I will email her today and find out when she can get her in court, and I'll let the court know.
all right. Norma,
I'm step back.
all right, we're gonna recall it for August 31st. And that, oh, can I have the MTR back? We'll recall it for August 31st, and that August 31st date, we'll see where we are.
Okay.
Okay,
You need me to sign anything or just, I'll make,
okay,
okay.
just be here on August 31st.
Thank you.
All right, thanks. Jim.
Yes, you're welcome. Gabriel Martinez. All right, where are we on discovery?
Judge, I believe all discovery is intended.
Well, Your Honor,
Our knowledge.
actually, Your Honor, we filed a motion to compel because we have not received all the discovery in this case.
All right, what discovery have you not received? If you will, well, if you'll let the
Well,
state know.
well,
I
we,
think there was some lab discovery.
actually, when I talked to the state, they said they were gonna dismiss the case if we went and we did a plea and misdemeanor. That was kind of a surprise to me
Yeah, yes, Judge, we have a plea worked out.
All right, so when are you on to take care of the misdemeanor?
right now.
All right, go take care of the
Thank you.
misdemeanor, then come back.
Great, thanks.
Thank you.
Thank you.
All right, thank you. On Ryan Westbrook, what is happening with that case?
Judge, and I've got paperwork with me. I haven't talked to my co-counsel here who knows more than I do, but I think he got sentenced in federal court the day before yesterday. And I brought the stuff off Pacer to give the court as well as the state. But he's still in federal custody. He's going to be in federal custody because he's got consecutive sentences over there. On
so-
this 2-count indictment, but
If you'll talk to the state, so how many months?
well,
You know, federal court is the only court where they still count months like you're a baby,
yeah.
you know, because it makes you sound so young. Oh.
He got,
Yes,
he got,
I'm 200 months old, you know, people are like, oh, that's not old. And then you start doing the math. You're like, whoa.
he got 27 months consecutive to count two, but it doesn't say in here what he got on count two. So, but I'll figure that out. And I don't think a judgment has formally been entered yet because it just happened. But if you give me a few minutes, I'll report back to the court and I'll let you know exactly what I think happened.
Robert Galvan.
Yes,
Hello, welcome back from your vacation.
Thank you, Judge. I'm glad to be back.
Yeah. So how was it?
It was great.
So was it a staycation or did
It
you
was
leave?
Port Aransas, so just a little family time. Brought the dog, brought the fiance, and that was it.
Oh, no, that's
Yeah,
awesome.
just a little chill time.
I always say it's like the song, everybody needs some time away,
There you go.
sometimes far away from each other. Yes, I love Chicago, right? All right, so where are we on this case?
Yes, Judge. So I need to look at. There's something I want to look at in the body cam footage, but other than that, I think we're ready for trial. We have gotten a plea offer,
Okay.
But it sounds like we're gonna try this one.
All right, Ms. Ferguson, how long do y'all expect this trial to last?
I would anticipate 3 days with jury selection.
All right, Ms. Ferguson, on this case, set this for a jury trial and plea deadline date in August, please.
Yeah, 17.
August 17th. They'll bring you over dressed for trial.
Okay,
All right, thank you.
we'll be here, Judge.
Thank you. Oh, if you
Judge.
can do an acknowledgement of discovery.
I have unavailability. I'll be in Travis County for a hearing on the 17th.
All
But
right.
I will be back on the 24th, the following Monday.
Wait a minute. You're in Travis for,
So I'm in Travis on Monday, I'm in Bastrop County Wednesday, New Orleans that weekend.
okay, New Orleans, you're not doing anything. I know.
It's our wedding in October the 4th, and so I gotta do the walkthrough and final payment August 2021.
Oh, you are getting married in New Orleans?
Yeah, I am.
Okay.
I'm excited.
Well, all right, Norma, set this for August 10th. Yes. All right, see you then.
That'll work. We'll see you then.
All right, and he'll need to be brought dressed for trial. And State, if you could do an acknowledgement of discovery, please, on Galvin. Adam Vasquez.
And we approach Judge?
Yes. Court is calling 2026 CR 002624 State versus Adam Vasquez. Can I have parties announced for the record? State? Defense?
Jason Todd for Mr. Vasquez.
And are you Mr. Vasquez? Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Probation, this is an application. And it's an application for deferred adjudication. Mr. Vasquez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Correct, that's not.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, it appears that you're proceeding on count 2 and waiving count 1.
Yes, Your Honor.
Any objections?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it
Yes, ma'am.
and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state was calling the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Judge, we've discussed possible defenses and the case.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Vasquez, anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Did you? I am so sorry. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. You know what the problem is? I'm reading the stipulations at the same time as this. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is waiving count 1. They're proceeding on count 2. There's a $1,000 fine to be probated. State recommends deferred adjudication. There's to be restitution to the Bexar County Crime Lab for drug testing of $120. Did you understand that to be your plea?
Yes, ma'am.
State defense?
It is, Your Honor.
That is correct, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
There were not, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation, 100 hours community service restitution, MRT, and the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense in count two, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Stenographer states one at a time.
No objections, Your Honor.
All right, state you may be excused. Am I talking too fast?
One.
Did you review the waiver and stipulations with your attorney?
Yes,
Did you understand it and sign it in all the appropriate places?
yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. Court will review the same. The court will find that the evidence is sufficient, and to find you guilty, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would first of all just ask you to follow this plea. This was a mistake, and he's ready to get back to his life. Not a mistake in the sense that he didn't choose it. He realizes that his choices were a mistake. He's taking responsibility and is ready to get back. He worked very, very hard. And he's honestly just, in all of our conversations, our biggest struggle has been getting him to find time outside of work. And so, which I think is not a bad thing. I think it's a good thing that he is focusing on better things than what he was doing that evening.
All right, if you're drug tested today, what are the results going to be? And you will be drug tested today.
I mean, just whatever those CBD stuff I get from a shop, that's it.
You're not allowed to.
Oh, I wasn't sure.
Yeah, you can't use any
No,
type of.
it won't be after this, but
Okay. So what do you do for work?
electrician, ma'am.
And do you have any children?
Correct.
Yes or no?
Yes, ma'am.
What are their ages?
There's multiple. We got 5, 9, and then 11, 12, 16. Yes.
Wait a minute. Just 1 second. Okay, what ages?
5, 9, 9 and 10. Ages under 12, and they're 16. Correct.
So 5, 9, 10, 12, 16?
Yes.
And do they live with you?
At the moment, not currently. Get them weekly. Right now, I've been single for the past about like a year and a half, almost 2 years.
All right. And in the stipulations, they say that he had several municipal court warrants or whatever. Has that been taken care of?
I am not aware that they have been taken care
I'm sure I know we brought it up to Ramos talking about it.
So we're taking care of them.
All right. Because here's the thing. Municipal court, they've stopped picking people up if they have warrants in their court. So there's nothing we can do about that. But if you're out and about driving, they can arrest you. All right. Court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, restitution to the Bexar County Crime Lab of $120. And the regular UAs, you can either do regular UAs or either you can do the patch. They will tell you with the patch, it costs more. However, the patch is going to show up everything. And if you're going to be positive, then make sure that he's tested for levels and do not put the patch on him until he presents with a negative UA.
Yes, ma'am.
Proof of employment within 30 days, no employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the restitution hours will be deemed satisfied. Field visits 1 time per month for 2 months. TAP evaluation out of custody. Follow TAP results or recommendations, I should say. Probation, is there anything else?
No, ma'am.
Is there anything else you need from the court to be successful on this probation?
No, ma'am.
All right, make sure you stay in touch with probation and stop using.
Appreciate it.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
And I'm sorry, add no possession of firearms, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court, okay?
Yes.
All right, and take care of those tickets.
Appreciate it. We're done.
All right, good luck.
Thank you, Judge.
Court is calling 2026 CR 00786 State versus Nathaniel Alvarez. Can I have parties announced?
And Jonathan Alvarado for the defense.
And are you Mr. Alvarez?
Yes, ma'am, but Your Honor, you got my first name wrong.
Oh, Nathan?
Yes.
Oh, I'm so sorry. See, you need to let people know, because otherwise they will say it wrong forever. So are you Nathan Alvarez? Okay. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Alvarez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, did you review the true bill of indictment with your attorney? I'm sorry, with your client?
Yeah, yes, Judge, I did, yes.
And do you understand the true bill of indictment? Counsel, do you waive the reading?
Yes, Judge, we wait.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Alvarez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with obstruction or retaliation as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe so, Judge, yes.
Mr. Alvarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, there's a $1,000 fine to be probated. State recommends deferred adjudication. They will take in consideration 2026 CR 0078669. Did you understand that to be your plea?
Yes, Your Honor.
State defense?
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
No.
Counsel, any such motion?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service, and the life skills course. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, CDOC receipts exhibit 1 and all attached.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
How old are you?
19.
Why are you living? They say it's a shack. I don't know if it's a shack or if it's a guest house, but in the report, they say it's a shack. Why are you living in a shack on your mother's property, getting intoxicated and bringing, I guess, your girlfriend, whoever else it is, to get intoxicated? That is very disrespectful to your mom. Why are you doing that? Well, I mean, what do you do for a living? Do you work?
Yes, ma'am. I'm a roofer.
Did you graduate from high school? So why are you getting intoxicated and bringing random people to your mom's backyard? And did she ever agree for your girlfriend to be living in the shack?
Yes, ma'am. It's because we had like a piece of stuff, like a little casita in the back, but we're rebuilding it.
Mm-hmm.
So now it's like we're making it to a room.
Do you know they said that you cursed at your mom doing this? Have you apologized to her?
Yes.
When's the last time you drank alcohol to intoxication, and then there was marijuana there too? When's the last time you did that?
Alcohol was that time, you know, but marijuana like a couple weeks ago.
All right. So let me just tell you, you smoking marijuana, perhaps maybe high or not. If you're on a rooftop, you could fall, and guess what? That's all on you. You understand?
Yes, sir.
Do you have any children?
No.
Are you still with this girl?
No, yes.
And is your mother still allowing you to live there?
Yes. I just made an offer as well, Judge. In speaking to my client, when I first met him in custody, he immediately acknowledged to me that he was intoxicated when this happened. He was remorseful for his actions, especially when it comes to how he treated the police as well as his mother. Talking to him today, as he said, he's a roofer. He works for a company his family member is also part of. He had been in school, but he's working pretty much full time now. And so he's a young man. He obviously made a really, really bad decision that day, but I think he's extremely remorseful for his actions and he wants to show the court he's changed.
Have you apologized to your mom?
Yes.
All right. What I can tell you, I guess I can say this, but I don't drink. It doesn't taste good to me. But I don't know how somebody can become so intoxicated that they end up directing profanity at their mom. If your mom is not like the mom in civil, there's no excuse for that. And she will always remember that. And stop bringing random people back to the housing that your mom has so graciously given you. You understand? Don't even ask her, hey, can I bring this person to live here? You know, just random people you don't even know. And I know the other a guy who was there, I don't think the mom agreed to that.
No.
Okay, so your family needs to stop allowing the young people to drink to intoxication. That is not good. You understand?
Yes.
And I don't know what female would feel comfortable with 2 intoxicated guys in a room with them, and then she's intoxicated as well. That's not good. You understand?
We were young country.
Sure.
We were at my cousin's and I had got home and that's when like everything happened. Cause I wasn't home.
Mm-hmm.
Yeah, I got home all intoxicated too.
So everybody intoxicated. Was there a single person in that shack who was not intoxicated? And do you know how intoxicated you have to be for your mom to call the police? And then they had to call, you know, the fire people out to make sure that nobody's going to die for intoxication. All right, this is what the court is going to do. The court, do you have any children?
No.
Don't have any children until you work on yourself, okay? Court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person. Regular UAs, I want him tested for levels.
Yes, ma'am.
$1,000 fine. That will be probated. Proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits 1 time per month for 3 months. Make sure you all talk to the mom. 100 hours of community service restitution. I don't know, does he need a probation? Does he needs a life skill course? He's just a young, I know he's an adult, but he's a young child living in his mom's backyard, getting intoxicated like it's Animal House.
And he's working
Yes,
with a skill.
he's a roofer.
I think life skills would be appropriate.
All right, so 100 hours of community service restitution. We're going to do the life skills course. Once that's completed, the community service hours will be deemed satisfied. And there should be no possession of firearms. And we'll do a TAP evaluation out of custody, follow TAP recommendations. If TAP recommends inpatient treatment, start with outpatient treatment. Probation, is there anything else?
No, ma'am, you got it all. Thank you.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Okay. Here's my recommendation to you. There are some movies that are great movies, and they have what I call life lessons in them. You know what movie you should watch since you use profanity against your mom? You should watch the original version of this movie called Imitation of Life. Okay? You watch that, it will most definitely make you appreciate your mom more. Okay? All right, good luck to you.
Thank you, Judge.
You're welcome. Who's next?
Gabriel Martinez, page 1 down.
Gabriel Martinez. Yes.
Good morning, Judge.
Good morning. Have you all completed your mission?
We did. Successful.
Okay.
Thank you for all your help.
You're welcome. All right. How old are you?
21.
21. Make better decisions in your life. You don't want to be back here. You understand?
Yes, ma'am.
You don't want to be, well, you've been in custody before and you don't want that, right? So make better choices. Okay? Good luck to you.
Thank you, Judge.
You're welcome. Clayton Saunders. All right. And so I want to let you know your clients appeared with shorts on the Zoom.
Oh, okay. I'm sorry, Judge.
All right, so what is happening with this case?
We
Counsel?
submitted our PTD agreement a few days ago, so I expect hopefully in the next week he'll have done his intake and he'll be accepted into the program.
All right, Norma, I need a PTD date.
I can do August 31st.
All right, Mr. Saunders, you can unmute.
Okay. Yes, ma'am.
So when you appear by Zoom, you have to dress as though you're in court. You understand?
Yes, ma'am. I have jeans on.
Okay, all right, thank you. All right, so August 31st, hopefully you will have completed everything. Make sure that you put, that you follow through on everything, okay?
So everything has to be completed by August 31st?
That's just your next date, and you can appear by Zoom, all right?
Yes, ma'am.
I'll talk to you. Wait.
Okay.
All right, thank you. Have a great rest of your day.
Thank you, Judge.
Thank you.
Welcome. Kimberly Tarwater. All right, so today is plea deadline date.
We need a jury trial setting, Your Honor.
All right, how long do y'all expect this trial to last?
It is a multiple jurisdiction.
All right, Norma. They need a jury trial date. Can you put this on the 18th of August?
Okay.
All right, August 18th.
Thank you, Judge.
Once you sign the reset form, you will be excused. You too. And then let me make sure I have an acknowledgement of discovery. State, if you can do an acknowledgement of discovery, thank you. Tommy Armstrong.
Your Honor, he's right outside the courtroom. He's saying he has a new strain of COVID
And we don't want that here.
yes.
And it's a new strain.
That's what he was.
Is this alpha or omega? We don't know. All right, so it's set for discovery. Have you received all discovery?
We have, Your Honor.
Thank you. And was an offer tendered?
There was, Your Honor. We also would have liked to ask the court if we could get a referral to a Veterans Treatment Court. He's a veteran.
Okay. Norma,
Yes, ma'am.
set this for a plea deadline date. You want to do August 31st?
Yes, ma'am.
All right, and then do a referral to Veterans Treatment Court.
Yes, ma'am.
All right, thank you.
Your Honor.
On page 92 down.
Thank you. Veronica Wicks. And have you all conferred with probation?
We have, Your Honor.
And you're all ready to proceed?
We're ready. The state will have a recommendation.
All right. Court is calling 2025 CR 003243, State versus Veronica Wicks. Could I have parties announced?
Yes, Judge Brennan, prayer for the state.
Michael J. Sawyer for the defendant.
And are you Ms. Wicks?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Veronica Wicks who was placed on deferred adjudication in this cause number for possession of a controlled substance, penalty group 1 to 4 grams, on May 12, 2025 for a term of 5 years? Is that you?
Yes.
State?
Judge, we proceed now in violation of condition number 4, specifically that in Berry County, Texas, the defendant, Veronica Marie Wicks, did then and there fail to report to the supervision officer as directed for the months of April and May 2026, violation of condition number 4.
How do you plead to that? True or not true?
True.
And the state will waive the remaining allegations.
Any objection?
None, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Judge. The proposed agreement is to amend the conditions for Saturday.
All right. So here's my question. When she was first placed on deferred adjudication, I ordered a referral to felony drug court. Was that done?
No.
Probation, do you know if the referral to felony drug court was completed?
Working on that right now, Judge.
And while they review this, is this the proposed agreement you want the court to follow?
We would, Your Honor.
Judge, it does not feel like it was done.
All right. I'm going to give you a choice. One, I can follow the agreement, but it's going to be a referral to felony drug court. Do we need an updated TAP evaluation on her or no?
No.
All right. So I can follow your agreement, or I can revoke you and sentence you, and I'll sentence you to 4 years in prison. Which do you prefer?
Oh, I agree.
All right. Court is finding violation of condition number 4 true. I want the following done in custody. I want a referral to felony drug court. If not accepted, then it's going to be SATA. And upon release, I'm going to want 2 sober support meetings per week. And there's to be no residing in households with children, with minors, and no unsupervised contact with minors. Probation, is there anything else requested?
No, ma'am, we can do all of that.
All right, is there anything else you need from the court to be successful?
Your Honor, my client asked me to request the court. Can she get some kind of job counseling to help her out?
All right, and if we could do a job skills course, please. Okay.
Thank you, Your Honor. That's all I have.
Good luck to you. Here's the thing, you got to report.
Yes, ma'am.
And if you think that you're going to use, that's when you need to call probation and let them know so that they can redirect you. or either when you go to sober support meetings, get a sponsor and call them up and say, hey, I'm thinking about using. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Yeah.
You're welcome.
Thank you, I'm excused.
Yes.
Have a good day.
Well, thank you. Christina Moreno. All right. So there was an issue with this case because of Axion. So what's going on?
That was resolved.
Okay.
Now I've been given offers, I've talked to my client, I've shown her this video, the one that really matters. And my client does not want to take an offer.
Okay.
And she wants a trial, so we need a trial set.
All right, Norma, jury trial date. All right, August 18th, and you need to make sure you're on time. Do you understand? All right, once you sign the reset form, you will be excused. And if you all could state on Christine Marino, if I could have an acknowledgement of discovery, please. Thank you. You're welcome. George Garza. Hello. Oh, and we have another municipal court thing for your client.
Municipal court.
Yeah. So anyway, municipal court, they are not accepting any of these warrants. So, you have some people who are in custody. So I'm like, oh, this person has a warrant. And when it's from municipal court or JP, they're like, we're not coming to pick them up. So he has a failure to maintain financial responsibility insurance. So you better check on that.
Yes, sir.
All right. Otherwise, I don't know, the police may still pick you up. Okay, now that that is out of the way. Where are we on this case? I know last time you were unable to view the discovery.
Essentially get one final discovery, so right, I want the chance to not give to our office now, and I'm serving contractual wish.
All right. Norma, 30-day reset. All right, August 30. Yes. All right, the state is, okay. State is saying they need 45 days. Are you okay with 45 days?
That's fine.
What date?
1 second.
September.
Yeah, September 14th.
All right, September 14th. Thank you for dressing appropriately for court.
And what is that for, Judge?
Do y'all want to put that as a plea deadline date?
Yeah, that's fine.
All right, it's a plea deadline date.
Loretta Holmes, page 10, few down.
Larietta Holmes.
Judge, we're on just a probation, status, compliance, yes.
Probation?
Yes, ma'am.
On this case, how are things going?
From what we can tell, excuse me.
Have you been doing your sober support meetings? 1 per week?
Yes. They do have some sober support meetings that have been scanned in. I did not look them over. Her last 3 UAs have been negative. So from May of 26, June of 26, July of 26 have all been negative. She completed her Bear outpatient program May 11th of this year. This recommend the client remain compliant with the conditions of community supervision by making regular payments toward supervision fees and restitution, completing remaining community service hours, providing verification of compliance at each reporting appointment. The client should continue working towards satisfying all court-ordered financial obligations and community service recommendations.
All right. So, Norma,
Yes, ma'am.
what we're going to do on this, we will do a final status in September, and if everything is fine, then maybe there'll be no more need for a status.
Yes, ma'am.
Is there anything else that she needs?
Yes, actually, there was another concern that the probation officer put on here that they had, I guess at the court hearing, they recommended an 18-month extension because ISP supervision was ordered. She is not eligible for ISP supervision because she's got less than a year left on her probation.
All right.
So,
All right, we'll address that at the next status.
okay.
Okay. All right, Norma, September date.
14th.
All right, September 14th for status.
Okay.
And then, depending on what happens or how she's doing, we may extend or not.
Okay.
All right, thank you so much. Thank you for the update.
Thank you,
No
Judge.
problem.
All right, Joseph Walker. All right, you have 2 pending cases from the precinct court. Failure to use a seatbelt and no driver's license. So you need to take care of that. Do you understand?
Yes, I made a payment on one of.
Oh, no. I'm just saying it shows open. So I'm just letting you know in case you don't know. All right, today is plea deadline date.
I received an offer, Judge. However, Ms. Espinoza and I have an offer, but there's some things that I pointed out in the videos that she's gonna review. So I'm hoping with that, maybe we can get a different offer.
All right, Norma, final plea deadline date, 3 weeks.
August 20th.
All right, August 20th, and you need to make sure you're on time for court. Court starts at 9 a.m. Do you understand? All right, you can have a seat. Once you sign the reset form, you will be excused. Thank you. All right, so what is happening with Javier Garcia? Oh, Javier Garcia, come forward. All right, you need to make sure you're on time. Court starts at 9. You understand?
Yes, ma'am. Sorry about that.
All right, so what is happening on this case with the phone dump and everything else?
So we conferred with the state prior to today. We hadn't had an offer. It was our first offer. We discussed that with him, but I think we still have some discovery issues. So we're requesting another pretrial setting until we can make sure we have all of our discovery.
All right, what is the outstanding discovery?
This over, I know having DPS detective bring me an external, I just need to double check that it was uploaded to Axon. I know we uploaded a significant amount last setting. I just need to double check that so I can try.
All right, so your final discovery setting, Ms. Ferguson, if I can have a 30-day reset?
It'll be 31st.
All right, August 31st. Make sure you're on time.
Yes, ma'am. Sorry about that.
Sure. Just have a seat. Once you sign the reset form, you'll be excused. All right, Javier Olvera.
We're ready, Judge.
Robert, on this case, the violation, we are going on the violation.
Yes, ma'am. Yeah, they're gonna dump the other case.
Okay. And there's an application,
Yes, ma'am. It's a recommendation.
and as soon as they're ready over there, I'll take you up. Court is calling 2026 CR 008220, State versus Javier Olvera. Can I have parties announced?
Opinion for the state of Texas. Robert Mauer for defendant.
And are you Mr. Olvera?
Yes.
Probation, this is an application.
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We did.
Court will find that the state is in compliance with discovery. Mr. Olvera, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
We do.
State, are you proceeding as presented?
Yes, we are, Your Honor.
Mr. Olvera, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with violation of bond or protective order more than two times or more within 12 months. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Ms. Olvera, Mr. Olvera, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Before we move on to the plea bargain page. No, you did not. I have a question. So there's a no harmful or injurious contact with the complainant. So number one, is there a protective order in place?
I'm a fair protective order with bond conditions.
It was bond conditions. The complainant had apparently done an A and P.
Mhm.
There's no contact. The violation was them living together. So we just want to make sure that there's no further violations.
All right, so here's my question. Have you spoken to her? Does she want to live with him?
We have to attempt to. He is not.
All right, so
I think
this
she's
is,
avoiding the contact because she wants the charges dropped.
all right, so here's the thing. This no harmful or injurious contact, I know that's a part of your plea bargain agreement. I don't follow that when it's assaultive behavior or if there's some type of violation until the complainant, lets me know that they're fine with this. So if this is going to be a deal breaker for your plea bargain agreement.
Well, I think the problem is, Judge, it's going to set them up for automatic failure because I think the reason she's not contacting the DA's office is she wants the charge dropped.
What do you want to see if somebody wants to talk to her and see if she wants to zoom in? If she zooms in and says that she just wants a no harmful or injurious contact, then I'm inclined to follow that.
Judge, I can try calling her. I can tell you, I'm out tomorrow and I can't be back this afternoon, so I have to try to do it maybe Monday.
Okay, if y'all want to do it Monday, or if y'all want to see if you can get in touch with her now to zoom in.
I'll try calling her.
All right, just have a seat. Court is calling 2025 CR 011882, State versus Jeremy Bass. Can I have parties announced?
Greg Gameray for Mr. Bass.
And are you Mr. Bass?
Yes, ma'am.
Counsel, have you received all discovery that you reviewed with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Bass, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Bass, did you review the court admonishments with your attorney? Did you understand it?
Yes, I did.
All right, you're charged with theft of property, $2,500 to $30,000. As a state jail felony, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution to Total Quality Logistics in the amount of $16,000.10. The court will note for the record that the court has been presented with proof of payment of restitution of $8,000.
That's correct, Judge.
And I guess this will be given to Timothy
Philberg, yes, Judge.
Philberg, THILBERG. And I'm sorry, it's $16,010.10. And of that amount, he's paid $8,000. Did you understand that to be the plea?
Yes, I did.
State defense?
Yes, sir.
We did, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years, a TAP evaluation, 140 hours of community service restitution, anti-theft course, no contact with Total Quality Logistics, Timothy Thielberg, Thilberg, and Matthew
Right.
Moranta.
Right,
Yes,
yes.
Moronta. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State's Exhibit 1 and all attachments.
No objections, Judge.
All right, did you review the waiver and stipulations with your attorney? Did you understand it? State you may be excused and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Your Honor, my client is aware, obviously, of what he done, and he has taken means to rectify that. And we just ask you to follow the plea bargain.
All right. How much are you able to pay towards the remaining restitution per month?
Every month going forward?
Yes. And don't tell me what you think I want to hear. Tell me what you're able to pay.
Going forward until it's paid off, I would say 150. More than likely more, but just to be safe this time.
Right. So he's to pay, it's 5 years deferred adjudication. He's to pay $150 per month towards the remaining restitution of $8,010.10 to Total Quality Logistics. And that's Timothy Thielberg. There's to be no contact with Timothy Thielberg outside of paying restitution. And there's to be no contact with Matthew Moranta.
Is there anything?
Or Total Quality Logistics. So what do you do for a living now?
Right now, I rent out my vehicle on Turo. I also have these inflatables that we rent out every weekend and throughout the week. I also detail cars. It kind of brings my income right now to about 3 to 4K a month.
Okay.
But I will be starting a logistics company pretty soon in September, October, and that'll be more like my career.
All right, there's to be no employment as a home health care provider with minors. He's to provide proof of employment within 40 days. There's 140 hours community service restitution. Do you have children?
Yes, I do.
What are their ages?
I have 3. One is 15, one is 11, and one is turning 3 in September.
All right. 150 hours community service restitution. I'm already parenting classes. Once that's completed, 70 hours will be deemed satisfied. The remaining 70 hours will be deemed satisfied once he's completed the anti-theft course.
Thank you, Judge.
There's to be regular reporting by Zoom or in person, regular UAs, Field visits 1 time per month for 3 months. Probation, do you want no firearm possession?
Please, and, the 10th class, you want 11 2?
Yes. And there's to be no firearm possession.
Your Honor, if his wife is in possession of a gun, how does that extend?
Oh, you all will need to come back and ask me to change my orders.
Yes, sir.
All right. Is there anything else you need from the court to be successful?
No, ma'am. Thank you.
And you're welcome. There's a $0 fine. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand that?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. All right, good luck to you. Stop making bad choices, okay?
Yes, ma'am.
All right, thank you. Joseph Gonzalez.
That's working on court.
All right, so what are we here for?
Judge, we're here for
For
a
restitution?
hearing.
Yes.
Unfortunately, Judge, we've had some problem with making contact with our complaining witness after the plea. I've spoken with opposing counsel. We're okay with doing a short reset to next week. I should have something back by the end of the day, and then we can meet next week via Zoom, if the court will allow.
Your Honor, I have no problem being here. I just asked that, if my client be allowed to join via Zoom, that would be appreciated. Beautiful.
All right, Norm, I need a reset date for restitution. They're saying next week, give them 2 weeks.
I can do August 13th.
All right, August 13th, and the defendant may appear by Zoom. You're welcome. And counsel, if you'll just let your client know when you're present, so they won't be on Zoom for a long time.
Yes, ma'am. I will coordinate, and he was on time, so I feel better.
All right, thank you. Once you sign the reset form, you're excused. Robert Maurer,
We're good. Rick's gonna enter her number. He talked to her. Hopefully the dialing 1-900 numbers on my phone.
Okay, so Rick has already talked to her?
Yes.
Okay,
I talked with her, she said she wants no contact order lifted, she wants it to now.
all right, let's come forward.
Love Bloom.
All right, we're back on the record in 2026 CR 008220, State versus Javier Olvera. Can I have parties re-announced for the record?
Rick Painter for Cedar, Texas.
Robert Maurer for defendant.
All right, and you, Mr. Olvera?
Yes.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right, so according to the plea, punishment is to be assessed at 6 years in prison, $1,500 fine. State is recommending community supervision. There's to be no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, sir.
State defense?
That is a plea, Judge.
Yes, Your Honor.
All right, and state, with regards to this no harmful or injurious contact, did you have a chance to speak with the complainant?
I did just consider, Your Honor. I asked her a series of questions, and after a series of questions, she basically does not want to have more.
All right, and is that correct, counsel?
That's correct.
And counsel, I believe you stated earlier that she had also filed an affidavit of non-prosecution.
Yeah, I don't have a copy of it. She might have provided it to SAPD, but I know she had indicated that she wanted to drop the charges. I think that's why she wasn't responding initially.
Okay. All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. 200 hours community service restitution, anger management, TAP evaluation, follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. Please send a safety note offering.
No objections.
Exhibit 1 of all its actions.
Okay. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And state, you may be excused.
Thank you, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, I just asked the court to grant his application. He's been incarcerated for 5 months on and off bond. So I think he's ready to get on with his life.
How old are you?
56, ma'am.
All right. Here's the thing. You're going to be in probation out of this court. She is saying that she wants you, I guess, to move back in with her. You know better than I do what your relationship is like. Maybe this is a relationship where you all shouldn't be together. You understand?
Yes, ma'am.
Because if the court receives a phone call that you violated the court's orders, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right. When's the last time you had employment?
Oh, I worked all my life, 25 years.
He does concrete work, Judge. He's just been unemployed since he got incarcerated.
All right. Are any children in that household?
No.
All right. The court is finding you guilty. The court will sentence you to 6 years in prison, suspended and probated for 6 years, regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody, follow recommendations. However, if TAP recommends inpatient treatment, we'll start with outpatient treatment. There's a $1,500 fine that will be probated. There's to be no harmful or injurious contact with Marella, Mariela, Barrera. Field visits 1 time per month for 3 months. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. No residing in households with minors. 200 hours of community service restitution. The court is going to order anger management. Once anger management is completed, the community service hours were deemed satisfied. No possession of firearms. This is a conviction, and it's felony conviction. You're not allowed to own any firearms. Do you understand? Okay. Probation, is there anything else?
No, ma'am.
Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right. Good luck to you. Make better decisions.
Thank you, Judge.
And do you have the other?
No, it's.
Frank,
I'll get that.
All right. All right. Azula Ziermel. All right. Good morning.
Morning.
So you just repeat everything that I'm saying. All right. So what is happening today?
Judge, we'd ask for a reset so I can further investigate some of the things I've learned today.
All right. Do you have any questions? And how long is this going to take?
Because of the language issue, probably at least 45 days.
All right. So did you tender an offer?
Yes, sure.
Oh, if you could speak up so I can hear. I love different languages. And so, let me hear is it Persian?
It's Pashto.
Oh, yeah, let me hear the language.
Yes.
All right. So how long would you all expect this jury trial to last if it's a trial? Because he has 2 cases.
Correct. Obviously, the assault case is the more pressing case. It'd probably take a whole week.
All right. And all right, Norma.
Yes, ma'am.
And I hope you'll be available. If you will not be available, let me know. Norma, set this for a jury trial and a plea deadline date in 60 days.
Thank you, Judge.
All right, are you available?
I'll be available.
September 28th?
Yeah, I'll be available.
All right, so they're going to give a reset form just so you'll have it. And so we'll need you for that entire week if they decide to go to trial. All right, thank you so much.
So much.
Thank you, Judge.
You're welcome. Oh, and sir, if next time, I'm sure if you need the headphones for him, just let us know. And I know that the interpreter upstairs will be more than willing to provide that for you.
I'm familiar with it because I had a last file and we used that. It helped a lot.
Okay.
Yeah, all right, thank you so much.
You're welcome. Thank you. Who's next?
It is Lacey Wheat, page 3, one down.
Lacey Wheat. And Norma, you have the interpreter's number?
The one that has it is the South Thomas is the one that can contact with me.
Okay, it's your, if you'll make sure they know the name.
You know, I'll by today.
All right, thank you.
Different.
Good morning. How are you doing today? What's the tears?
She's just, we're working towards resolving this ordeal for her, Judge. It's been a lot of stress on her.
All right, so where are we on resolving this?
Still outstanding discovery, no CPS as of this date. Last court, we did bring that to light for the court so we can have that. And I was just informed by the state today that they do not have that in their possession. So that's
right. The CPS matters. Is that from Bear County? Can somebody pick up and call the prosecutor on the CPS side and just say, hey?
That's what I was kind of suggesting. I did speak with. Go ahead, Judge.
No, because if there's a CPS matter that's ongoing, the prosecutors over there will have the CPS records.
Your Honor, I believe at this stage, it is delaying the proceedings. I know the DA's office has a number of investigators, paralegals, as well as attorneys, and the fact that we do not have that at this date is concerning for me and my client in deprivation of her due process rights, Judge. We did file a writ of habeas corpus pursuant to 17.151 due to this delay. She is in custody and she has been in custody on this alleged offense.
And let's do this. Let's recall this. We're going to recall this in 2 weeks. CPS records, they need to have them. If they don't have them, then we can take up whatever matters you wish to take up and the court will hear whatever motions you have.
Yes, Your Honor.
All right. And the reason why I'm giving the extra time is because we were here June 16th about the CPS records. And I understand sometimes CPS records, if they're not ordered when whomever was in intake doing this, there's an issue. So we're going to come back in 2 weeks to get that done. August 13th. And then what is her bond?
Her bond is set at $150,000, Your Honor, and we did file a motion to reduce that bond. And my client is asking that the court consider reducing the bond. I know typically in these type of cases, $150,000 is an extreme amount.
Right. Are y'all ready to proceed on the motion to reduce bond?
We're going to stand down because that bond was not, actually there's that bond grand jury.
Well, I mean, let's not.
I would say the grand jury doesn't have a lot of insight as to how legal matters work. They're lay people, are members of the community. So
well, let's not stand silent. I'll still need some evidence. So it's noon. Are you able to come back this afternoon?
Yes, Your Honor. All
right. So we're going to come back on Miss Lacey this afternoon at 1:30 to hear her matters.
Thank you, Your Honor. Feel free to hear that. Thank you.
Keyshawn Merritt. And is there an application?
Yes, ma'am.
Yeah. And is it opposed?
Yes.
All right. I need a PSI date, please.
Yes, ma'am. Give me 1 second, Judge.
Hello. Is there going to be a need for a tap?
We'll take one.
All right. Probation.
Yes, ma'am.
It's going to be a PSI and tap evaluation on Keyshawn Merritt.
Thank you.
And it's going to be set for September 14th. And is there a need for any mental health evaluation?
We'll take one as well.
All right. And it's going to be a MIC evaluation as well.
Yes, ma'am.
Court is calling 2025 CR 015747C and 2025 CR 015750B. State versus Keyshawn Merritt. Can I have parties announced?
Let me grab behalf of Mr. Merritt to my right.
And are you Mr. Merritt?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
To the best of my knowledge, and yes.
Court will find that the state is in compliance with discovery. Mr. Merritt, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment in each of these cause numbers with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, please.
State, are you proceeding on the indictments as presented in each cause number?
Yes, sir.
Mr. Merritt, did you review the court admonishments in each cause number?
Yes, ma'am.
And the cause number ending in the letter B, you're charged with robbery. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that case, the court could find you guilty. If a motion to revoke were filed, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. And the cause number ending in C, in counts 1, 2, and 3, you're charged with aggravated robbery. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication, will revoke, the court could find you guilty and sentence you to life in prison in counts 1, 2, and 3, and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause number? Counsel, has your client been Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Merritt, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented? If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it? All right, according to your plea, the cases are to run concurrently. The state is taking in consideration 2026 CC 006033, 2026 CC 12013. The state is opposed to your application. And of course, counts 1, 2, and 3 will run concurrently. There's a cap of 15 years in each case in the prison, $2,000 fine. There's an affirmative finding of deadly weapon in the cause number ending in C. Did you understand that to be your plea in each of these cause numbers?
Yes, ma'am.
All right, state defense.
Yes,
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Then, in the cause number ending in the letter B, how do you plead? Guilty, not guilty, or no contest? And in cause number ending in C, how do you plead to count 1?
No contest.
To count 2?
No contest.
To count 3?
No contest.
State any evidence to support the defendant's plea?
Stafford states one in the top.
No, Judge.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you in each count guilty and in each cause number guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. We will come back on September 14th. At that time, I'll base my decision on whatever evidence is presented. With regards to the PSI, TAP evaluation and MIC evaluation, probation will probably see you more than one time. Just make sure you speak to them. Counsel, if there's an issue with the jail, as far as maybe there's a different rotation or something and they don't get a chance to see him, just let the court know and we'll make sure it happens.
Thank you, Judge.
All right, good luck to you. You're welcome. Thank you. Carlos Tiente. All right, why were you late?
Oh, I was at work, man. And I didn't get a notice till this morning, so.
I mean, you had court on June 16th.
Your Honor, we did speak with his wife yesterday. I think there was some confusion about whether it was today or tomorrow, but I can tell you that as soon as we got a hold of him, he rushed over.
Well, I mean, last time, did he sign a reset form?
Yes, Your Honor. And Ray did speak to him about that.
Yes. So next time you need to be on time. You understand? All right. So what's happening with this case?
Yes, Your Honor. So this case, as well as co-defendant Robert Ustrio, Vasquez, those both came to our court, were transferred to this court fairly recently. Lois Christian is on the Ustrio case. I'm giving them all of the discovery. I'm going to make sure the discovery on their case and this case are complete and complete by each other. The other thing I need to do on this case is, it seems that the defendant gave a statement that has not yet been translated. So I'm going to get that translated. They'll need 45 days to comply with the law, as well as the time for them to object anyway. Confusion on it. So I would ask this court for 60 days. If this court's willing.
Norma, recall this for 45 days for discovery.
John.
September 14th.
All right, September 14th.
Yes, ma'am.
Once you sign the reset form, you'll be excused.
Thank you, Your Honor. I'm sorry about that.
No problem. Thank you. Mickey Vasquez.
How you doing, Your Honor?
Oh, I'm doing okay.
Judge, on Mickey Vasquez, there's some additional information that it's on the file that I have not received. I think it will turn this matter in a resolution of a plea bargain. However, I need to review it. I may have a 2-week deadline, either for trial or plea or.
All right, Norma, set this August 10th for jury trial and a plea deadline date.
Thank you, Your Honor.
All right, once you sign the reset form, you're excused.
Yes, sir. I have one other matter, Your Honor.
Who's next? I just have a seat that bring the form to you.
Pedro on page 4 on the bottom.
Pedro Lara, Your Honor.
Pedro Lara.
Your Honor, at the last court setting, the court signed an order for the state to produce medical.
Yes.
And to date, they haven't, but they're still within.
All right, state.
Time frame.
Yes, sir.
Where are we on the blood discovery on this?
Has he come back yet? I circled back to the lab yesterday and haven't heard back, but I'll ask the lady at DPS again to provide an update. I know they had about a 60-day lead time last I found.
All right, Norma, recall this for August 31st.
Yes, sir.
Thank you, Your Honor.
Thank you. You're welcome.
For discovery, Judge?
Yes, and an offer is due at that time. All right, court is calling 2026 CR 001840-02, State versus Lacey Wheat. Can I have parties announced?
Renee Munoz on behalf of Miss Wheat.
And are you Miss Wheat? All right. Defense has filed a motion requesting a bond reduction. State, have you had a chance to review the motion? All right. State, are you objecting to the reduction?
State will remains, just add for purpose of the record that I looked into the reasons for why the bond, was set aside was, it was not a recommendation to the state. It was just a jury after they true build the case, do that number.
Right. So what I can tell parties is there needs to be some form of evidence presented to me. So is anybody going to present any evidence?
If I may call my client, Your Honor, for the purposes of the bond motion.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Lacey Charlene Wheat.
All right. You may proceed.
Thank you, Your Honor. Hi, Ms. Weed. So in terms of your residency here in Barrett County, how long have you resided here?
We moved here when I was 9.
Okay, and you are how old at this time?
64.
Okay, so around 45 years or so, you've been residing here in Bear County. Have you been active in the church at all?
Yes, I go to Grace Community Church. It's been almost 20 years, the same church.
You've been active within that church for 20 years, you said?
Yes.
Okay. Aside from this arrest in relation to this charge, when was the last time you were arrested?
Maybe in 1990, something like that, early 90s.
Okay, and do you remember what that was for?
I think I was driving with a suspended license, but I didn't realize it was suspended because it had been from no insurance for years.
And that's all the way dating back to the 90s, correct? Okay. And in terms of the $150,000 bond currently set, is that too much for your family to make?
That's way beyond anything.
It's way beyond anything you said. Okay. And in terms of your assets, do you own any assets?
A 2000 Honda Civic,
Okay. How many miles does it have on it?
265,000.
Okay, 265,000 miles on that. Okay. Would you be surprised to learn it like the Kelly Blue Book estimate was around $300 to $700 for that? Would you be surprised to learn that?
It's worth more than that to me.
Sentimental value. Okay. Monetarily.
Transportation.
Yeah, monetarily different story, right? Okay. And essentially you haven't worked actively since how long?
Since about 2012, 2013, I'm on disability.
Okay. And you're on disability, and how much disability do you get per month?
It's like 1,123 or 25.
Okay. And that's used for your day-to-day, your living expenses as well, right?
Yes.
Okay. No other further questions, Judge?
Yes.
Ms. Weed, what's your questions for you now? You said you're not working and you're supporting yourself on disability. What kind of support system do you have around this?
What kind of
Support system do you have? Yes, ma'am.
The property I live on is right next door to where my son lives.
Okay.
Um,
Do you own the property that you live on?
My son does.
Your son.
I'm
And other than your son, is there anyone else in your life as far as your support system goes?
he's my boyfriend when he's around. He works and stuff.
So your son is involved. Does your son work?
Oh, yes.
What do you do for a living?
He works for fire suppression system company.
Okay.
And then his wife also works.
Do you have an idea about how much he earns at that job?
I have no idea. I don't ask.
I would assume he earns enough though to buy the property, right?
Oh, we purchased the property before when he was younger.
Oh, understand. Okay.
My ex and I.
Understood. And what about your boyfriend? Does he work?
He works.
What does he do for a living?
He works at a barbecue place in Civil Rock.
Barbecue place. Is he like a server or something, or is he in a kitchen?
Yeah.
That's not it. All right. So other than you getting your disability, would you rely on either your son or your boyfriend for any type of financial support?
I wouldn't rely on him. No, I wouldn't want to.
Do you need them though occasionally, or no?
Occasionally.
Or
emergencies or something like that. But I don't want to do that.
okay. And my last question is: you understand that part of your bond condition is that you would not have any contact with victims, right? You understand that? Victim of the case?
Oh, definitely. They don't live there anymore.
No contact between you as the legal party. Okay. That's what you're trying.
No further questions or be direct, Judge.
All right. Any other witnesses?
No further witnesses from the defense.
I'm just
All right. So no other evidence from either party.
If the state wanted to put forth her NCSC, TCSC information, I wouldn't have any objection to that. Last time she was arrested was in the 90s, but if the state wanted to confirm that, if the court would like to see that.
I
I cannot mark it as an exhibit, but I can tender on court with the information. In 1984, defendant was arrested for a DWI, convicted and given 1 year of probation. 1997, the driving license suspended, as she alluded to earlier. Looks like 2 of those during that same year. No, it's that over by 1996, of course, she had another driving license invalid. Then the third one, 1997, driving license invalid. Other than that, Your Honor, that is the extent of the defendant's criminal.
But obviously in considering the
And while the state is downloading that, what bond amount are you requesting, counsel?
Your Honor, respectfully requesting the amount of $25,000. My client does not have an abundance of money. She has not worked in some time. She just basically gets disability just to sustain herself on. Further, she has deep ties to the community. It's not a flight risk. She's been here in the community for over 45 years and has participated in the church program for over 20 years, based upon her testimony here, Judge. She's not a flight risk. If she is released, she will attend all court hearings as scheduled and abide by all bond conditions, Judge. She's been in custody since June 13th on this. She basically is living her life, and then she got accused of this. The indictment triggered the warrant, and she's been in custody on this, Judge.
All right, and does she have any prior mental health issues?
She does have mental health issues, Judge. That's why she gets the disability.
I'm also severely anemic. I was in the hospital for 9 days. I don't know.
No. So with regards to the mental health issues, are you receiving SSI based upon that?
Yes.
All right, what's the mental health? What is your diagnosis?
I have severe depression, PTSD, ADHD, OCD, severe anxiety. I've had a lot of head injuries.
All right. And has there been any past drug use?
Very, very long time ago.
And what would that be?
Marijuana and occasional meth. Ever shooting.
As far as the bond request, you can go and make sure the allegations of this is a second degree felony and large service.
I'm sorry, what are you asking for? Okay. All right. And defense, I believe you said you had no objections to state's exhibit?
No objection for purposes of this hearing, Judge.
All right. For purposes of this hearing, only state's exhibit number 1 is admitted into evidence and the court will review it. And also, could you pass me this? The letter, no, that was with the other court reporter. All right. After hearing both arguments, this is what the court will do. The court is going to grant the motion to reduce bond. The bond will be set at $65,000. There's to be no contact with the complainant. I don't know how that's really going to be accomplished. I mean, because according to the stipulations that I received, it says that she lives in the house behind.
They moved, Judge.
Ah.
Yeah.
They weren't going to be evicted anyway, so that's fine.
Yeah, they're no longer in the vicinity.
So no contact with the complainant.
Even also request you this
I mean, is there any danger
Based
between
upon
her and the complainant?
no, there have been no other allegations any kind of instances of violence directed or threats towards a complaining witness, coupled with she doesn't have violent criminal history whatsoever, and she's been in the community, Judge, without any issues since the 80s. I don't believe that GPS would be a reasonable condition.
All right, I'm not gonna ask for GPS. I'll do UAs, waive the fees. There's to be a referral to Center for Healthcare Services. All right, is there anything else?
Nothing further from the defense, Judge.
Oh. And Norm, if you give her a reset form, because this case is being reset for August 13th.
Yes, Judge, will do. I'll execute that. She will as well, in case she's released, Judge. And then after that portion, may I be excused?
Yes.
Thank you.
All right, Max Henry Perez.
She's not here.
Council's present, Judge, on Zoom.
She's on Zoom.
No, I'm on, he's in the courtroom. I'm on Zoom.
All right. Court is calling 2026 CR 007183 and 2026 CR 007182, State versus Max Perez. Can I have parties announced?
Espinosa for the state.
Lindsay Shaw for Mr. Perez.
And are you Mr. Perez?
Ma'am.
All right. Any objection to your attorney appearing by Zoom?
No, ma'am.
State, any objections? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Perez, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the cause number and in 8-2, are you proceeding on the indictment as presented? And in the cause number ending in 8-3, are you proceeding on the indictment as presented?
No, Judge, state waives and abandons count 1 and proceeding solely on count.
Any objection?
No, Your Honor, and I'm apologize for my camera. I don't know why it keeps turning off.
Oh, okay. It happens.
Yeah.
But you're fine.
Okay.
All
thank
right.
you.
Mr. Perez, in each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. In the cause number ending in 8-3, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. In the cause ending in 8-2, you're charged with an unlawful possession of a firearm by a felon. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, I do not have to follow your plea. If I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea and each cause number, punishment is to be assessed at 3 years in the prison. There are no applications. The cases were run concurrently. There's a $600 fine in each cause number. And in the cause number ending in 3, the state is proceeding on count 2 only. Did you understand that to be your plea?
Yes, ma'am.
State and defense, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motion?
No, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor, state offer states exhibit one in all attachments under both. No, no objection.
All right, state you may be excused. And each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, Your Honor, I believe he is worthy of the plea bargain. We ask the court follow it.
And cause number 2026 CR 007183. As previously stated, the court is finding you guilty. Court will sentence you in count 2 to 3 years in the prison. There's a $600 fine. Time and money will run concurrently. This will run concurrent with 2026 CR 007182. Court will give you credit for any time served. And cause number 2026 CR 007182. Court will sentence you to 3 years in prison. Credit for any time served, $600 fine. Time and money will run concurrently. This will run concurrent with 2026 CR 007183. There's to be no unsupervised contact with minors and no residing in households with minors. In each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. These are felony convictions. You're not allowed to own or possess any weapon or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Ma'am.
How old are you?
42.
And you got to make a decision. Do you want to? You're so close to being in the twilight of your life. You know why I say that? Because unless you're planning on living to be 120 or whatever it may be, that would be great if we have all our faculties and we can still be independent. But you're 42, right? Maybe you'll live to be 84. But do you want to spend that time living at a prison? So you got to change. If you don't change, that's what's going to end up happening. You understand?
Yes, ma'am.
All right, good luck to you. Make better decisions.
Thank you, ma'am.
All right, good luck.
Sweet.
Good luck, Max. Thank you, Judge.
You're welcome. Have a good one. Tatum. My young Tatum. I think I pronounced the first name correctly this time. We shall see. Oh, Mr. Cox.
Yes, ma'am.
How's it going?
It's all right, Judge. This is just first sitting case.
Okay.
Out of 22 weeks ago. For the ink
You
is still,
appointed 2 weeks ago.
right, the ink is still, ink is still wet on the plan. But I came anyway, and I've conferred. So we just need I need some time to go over discovery on time.
All right. Recall this in 30 days for discovery. 31st. All right.
31st.
Thank you.
That'll work. Thank you, Judge.
You're welcome. James Hester. See. Jesse James Noel Hester. Probation, this is an application for deferred. Court is calling 2026 CR 003517 State versus Jesse James Noel Esther. Could I have parties announced?
Ready for the state, letter now for the defense.
And are you Mr. Hester?
Yes, ma'am.
Counsel, have you received all discovery at your review with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Hester, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Judge.
State proceeding as presented?
Judge, you can proceed on count one, waiving count two.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In count one, you're charged with possession with intent to deliver 4 to 200 grams. Penalty one, that's a first-degree felony. Range of punishment is 5 to 99 years or life in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to life in prison and up to a $10,000 fine. If you have a plea with the state, I do not have to follow your plea. If I don't follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Hester, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Absolutely.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 8 years in prison. State is opposed to your application. This is run concurrent with 2026 CC 008057. Did you understand that to be your plea?
Yes, ma'am.
State defense.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Judge.
Then in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, you have to say exhibit number one, including all attachments.
Except for the modifications I made to reflect the correct plea, we have no objections.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call them the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. How old are you?
I'm 19.
Does he have criminal history?
Not that I saw, Judge.
All right. So here are your choices. 1, defense, if you want to waive PSI, you can waive PSI. I'll grant his application for deferred adjudication. If you are given a motion to revoke, you're looking at potentially life in prison.
Yes, ma'am.
And what is with the bunny tattoo?
I was younger. I was stupid. I was bad on drugs.
Well, the bunny tattoo usually means more than being stupid, as you say. And I will put you on GPS.
I'm fine with
and
that.
People will be coming to your house on a regular basis. Do you live in Bexar County?
No, I live in Medina County.
We don't feel this is outside of the county, Judge.
Well, counsel, you have to find out information through probation about Medina County. Because one, I'm going to want him on GPS if I were to grant his application. And Medina County, there's probation there, a probation officer there. You have to make sure that Medina County is willing to do field visits because he needs field visits. And I don't feel that the community will be protected if field visits are not done with him. And who lives in this household with you?
My mom, my dad, my little brother, and my little sister.
And how old are they?
My mom and dad are both 28.
No. I'm talking about the children.
My little brother is, I think, 16, and my little sister is 11.
Yes, so that's what I'm gonna need. So when do you think you'll have that information for me, counsel?
I have no idea, Judge. Give me 2 weeks, figure that out.
Okay. And if you're drug tested today, what would the results be?
All negative.
Okay. All right, Norma, recall this in 3 weeks. Are you waiving PSI, counsel?
Yes, Judge.
Recall in 3.
August 20th.
Oh, August 20th.
Okay.
I'm not gonna be here.
Okay. Want it the week before, or do you want it the week after?
Do you want it the week of the 10th, counsel, or the week of the 24th?
I prefer the week of the 24th, Judge.
All right, put it down for August 24th. All right, thank you.
Yes, ma'am.
Okay. Yes, once he signs the reset form.
All right. So
Probation will just be back on August 24th. The defense has agreed to waive PSI. Milton James Franklin. All right, counsel, what is happening?
Good afternoon, Judge. I am his second attorney. I received an offer today.
Okay.
This is my first official setting. What he'd like to do is come by the office, talk more about the offer, and go over some discovery. So formally, we're asking for a reset and a date to announce our decision.
All right, Norma, recall this for August 19th for jury trial. Yes, jury trial and plea deadline date. It's Milton Franklin. 19th.
Judge, would you consider August 26th? I'm out of town on the 19th, 20th, and 21st.
All right, we can do it on August 17th.
Okay.
All right, August 17th, Norma.
Yeah.
Thank you, Judge.
You're welcome. And if your client could unmute, please. Norma, which page is this on?
It's off docket, Judge. He was supposed to contact me with.
Here we go.
He was supposed to contact me by email. He said this for a date. I was gonna contact me by email.
All right, what is this? What is this? His client's case number?
It's
Good afternoon, Judge.
Good afternoon. I'm sorry.
Are we by ourselves here, Judge?
Oh, just give me a moment. CR what?
005225.
No, we're not by ourselves. Your client is here, the state is here, and the state is able to hear everything. So.
No, I was just, can you see my background? I'm in Nassau and I was going to order you a virgin daiquiri.
Hey, I appreciate that. Be sure they put some whipped cream on it. You know, it's not a virgin daiquiri without the whipped cream.
Yes, ma'am.
I love virgin strawberry daiquiris. All right. So where are we on discovery and everything?
So this is the case that was set on Monday where we had conferred about the GSR. So we have a discovery setting up in October regarding that. The reason that the defendant and his counsel are present is because they filed a fifth motion to amend bond condition.
Yes.
And so that's what they wanted to address before.
All right. Could I see the motion?
Separate.
Oh, that's okay. Just so I can call. All right. The court is calling 2026 CR 005225 State versus Ramiro Espinoza Jr. Can I have parties announce for the record?
Megan Galloway for the state.
J.D. Garza defended Mr. Espinoza.
All right. And are you Mr. Espinoza?
Yes, Your Honor.
All right. So defense, from my perusal of your motion, you're asking that the defendant be allowed some time to move from his apartment or something?
Yes, Judge, from the house where he's currently residing with his mother-in-law and other family members. They did sign a lease yesterday or day before to an apartment, and he's requesting permission to rent a U-Haul truck and move his items out of the house and out of the storage to his new to him apartment.
All right. Do you have any objections?
Judge, so the disagreement is that they're asking for the defendant to have the weekend to do this, so I would agree to him picking either side.
Excuse me, Judge, I cannot hear.
The state said they would be in agreement to not the entire weekend. You pick a Saturday or you pick a Sunday, and that's the day you move.
Judge, may I put my client on the stand? I put in the weekend, but I'm not sure if that's going to be enough. Can we get Mr. Espinosa to testify how much time he's going to need and why?
Sure. Could you raise your right hand, sir? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor. I do.
Right. You can lower your hand, state your name for the record.
My name's Ramiro Espinosa Jr.
All right. How much time do you need to move?
If it's any other weekend, if it's one time out of every other weekend that I can do it, I just need to get the stuff out. I did send some photos to the my attorney stating how much items I have in that house, and mainly at the storage area. I'm trying to downsize that storage, and it being by my wife by herself, it's a lot of stuff for her, and she's also disabled herself too. You know what I mean?
Oh, wait a minute. I thought this is an apartment. Is it an apartment that you're moving from or a home?
It's an apartment. It's like a duplex apartment, and it's a good size though. But basically, it keeps me from having to pay what I'm paying at the storage to this point, and then lowers my payments from there. And also what I was having at stay at my mother-in-law's, where I was staying and moving the stuff from there because she wants that stuff moved out when I have the time, you know. And that's why I'm asking, even if it's one time out of every weekend.
No, stop. How many bedrooms at this duplex apartment?
All right, it's together, ma'am. It's a studio and then the two bedroom. So it's a big room. They made it into a bigger room, and then the 2 bedrooms, and then the living room and the kitchen.
All right. Any questions, defense?
Yes, Your Honor. Would you like to look at the photos that I sent to Ms. Galloway of the storage unit with all the stuff in there?
So he's moving out of the duplex plus a storage building?
No, he's moving into a duplex, but he's moving out of his mother-in-law's house and moving the things that he had in storage to his apartment or duplex.
All right. So I thought he currently lived in a duplex. So the home that you're moving furniture from and items from, how many bedrooms is that?
It's just a bedroom and like a little I call it a shed that I have stuff in and inside one room. That's where I have stuff there, and then in the room, and then I have a storage itself.
All right. Any other questions, Mr. Garza, for your client?
Well, Joe, yes, Ramiro, can you tell the court what are your work hours starting tomorrow, which is Friday?
I work from 6 to 4 tomorrow, but they know my situation right now with me having to move and all that stuff. They're willing to work with me, but normally I work from 6 in the morning to 8 in the afternoon.
Okay, but so tomorrow you can get off at 4, and then you're off. You're off Saturday and Sunday. Is that correct?
Yes, sir.
Okay, so between tomorrow and Saturday and Sunday, would you be able to move all the things that you need to move?
Not all of it, but most of it, yes.
Okay, well, then would you be able to move the rest of it the following weekend when you're off?
Yes, sir.
Okay, now you are still on a partial house arrest where you do wear a monitor, right?
Yes, sir.
Okay, and is this storage or is this apartment that you're moving to anywhere near the decedent's family?
Not any close to that area in any way. I don't know where that area is at anyway, so I'm not close to that area or anything.
Okay, and about this U-Haul, you would need a rental U-Haul. Is that right?
Yes, sir.
Anything else that you need for this move?
Just basically, just having permission to be able to get that U-Haul, and then again, I'm the only one with a license, so and that's where it makes it difficult. We can move most of the stuff with the vehicle, but most of the heavy stuff, I am gonna need that U-Haul, and I have a lot of heavy stuff.
I'll pass a witness, Your Honor.
All right, state.
Okay, so I need some clarity. So right now you're living with your mother-in-law, and what is that address?
It's 6007 Highfield Street, San Antonio, Texas 78238.
Okay, and at that residence, you're occupying one bedroom plus some belongings and a shed, and then you have a storage unit that's located where?
It's located off of Culebra Road, which I've already given that location to my attorney, but I can get it for you if given permission.
Okay. And then the apartment that you're moving to is the duplex that you stated to the court. Is that correct? That was like
Yes, ma'am.
2 bedrooms?
Yes, ma'am.
Okay. And then regarding your work hours, you stated that you work from 6 a.m. to 8 p.m., but that your work is aware of your need to move out of your mother-in-law's house and that they're willing to work with you. Is that correct?
Yes, ma'am.
Okay, so it is a possibility for you to take a day off from work to be able to conduct this move in one day if you dedicate all your time to that, correct?
If I can, ma'am, yes. But at the same time, too, there is, again, most of the situation is that I was trying to move all the smallest stuff, and then at the end, try to get a U-Haul to be able to get the heavy stuff out completely. I mean, I am focused. If I could focus on one whole day, but at the same time, if I get 2 days, which is one weekend, one day out of that weekend, and then another day and another from another weekend, I know I can get everything out. But even during the week, if I'm able, even if I go just to get stuff little by little, I can get it done before another weekend, so I don't have to ask for another weekend, you know.
So do you work Monday through Sunday or do you have days off?
I work Monday through Friday, ma'am.
Okay, so you have Saturday and Sunday off.
Yes, ma'am.
Okay, so then you would be able to dedicate your days off from work to your move, correct?
Yes, ma'am.
Then you stated that you're the only person that has a driver's license, but your wife does have a car and operates a motor vehicle, correct?
Yes, ma'am.
Okay. Then the other thing that I wanted to talk to you about is because you are on partial house arrest for work, and then you've previously been given permission to go to Ross, DD Clothes, and Pika Pika Plaza if you provide that in advance to your pretrial officer. Is that correct?
That's correct.
In addition to being able to go to church on Sundays, right?
Yes, ma'am.
Okay. And so recently on July 12th of 2026, you were engaging in unauthorized stops, correct?
Your Honor, I would object to that. Is not relevant. You sent that violation report to Judge Halstead, and Judge Halstead already ruled on it.
Well, I understand what you're saying, counsel, but I need the information in order to
make
a ruling on this, counsel. So I'll overrule that objection.
Okay, so on July 12th of 2026, when you were out for church, do you recall that?
Yes, ma'am.
Okay, and on that day, you went to Take 5 Oil and the Market Square without permission, correct?
That is correct, ma'am. But at the same time, too, I was dropped off downtown. I did pass through the Market Square to get something to eat, and I also gave that receipt of what was takeout, but I had to wait for my order, and then directly went in, and got in the bus to go home. My wife had to drop me out there because her mom was really sick, so she had to leave me there. Now, at
So
Take 5 Oil.
my question is, those were not authorized stops by pretrial, correct? You didn't make them aware of that before, right?
No, ma'am, because I didn't know that was going to happen.
Okay, just after the fact, right? You let them know?
Yes, ma'am.
Okay. And Miss Romo has already admonished you previously for having unauthorized stops, right?
Being the first situation that I've been through, yes, this is what the Take 5, and also that I went through that Market Square. Yeah, this is the first time that I've been through that. I haven't had any altercations or any other stops where I have not stopped that I'm not supposed to be at. I've always gone to my stop that I need to go to.
Okay, but just regarding that day, that ended up of you being unaccounted for 4 hours, right? Between Market Square and Take 5?
Yes, ma'am.
Okay. And then finally, just so the court is aware, you are a convicted felon and have been to prison twice before, correct?
Yes, ma'am, and I've done my time for all that, ma'am.
Okay.
And I've been out of trouble almost 20-something years already.
Okay. We pass the witness, Your Honor.
Judge, may I clarify a couple of points?
Sure.
Mr. Espinosa, tell the judge about the Take 5 Oil. What is that about? Is that a place where oil is changed out of your car or what?
Yeah, for the vehicle. And I was at the bus stop when she was at the Take 5, but the bus stop is right next to the Take 5 Oil, and I was next to the bus stop where it still showed the location that I was at Take 5.
But who was at Take 5? Your wife?
Yes, and she was put into Take 5, but I was next to the bus stop where
Something happened to the sound.
I know. I have no control over that.
Okay. Were you able to hear his response, Your Honor?
I heard the first one, and then everything else was sort of muffled.
Yeah. Okay. Let me ask you again. Mr. Espinosa, you're telling the court that you were at a bus stop right in front of Take 5 Motor Oil where your wife was having the oil changed on her car.
Yes, sir.
But you are not authorized to go to Take 5 Motor Oil. Is that right?
Not unless it's approved or through a motion. That's the only way.
Okay, and as far as the eating at the restaurant at Market Square, are you prohibited from eating, going into a place to eat and sitting down?
No, as long as it's a takeout or it's a drive-through, I'm allowed. But again, I was taking long because of the order, and it was a weekend. So even though I provided the receipt to her, she understood then. But still, at that moment, the way they saw it, that I probably sat in there and ate, which I didn't though. But that was the situation.
And this was during the lunch hour or when?
It was after church. It was Take 5, and then they ended up calling my wife because my mother-in-law got real sick, so she had to. It was an emergency, so she had to drop me off so I can get the bus route going straight home. So I ended up walking to the Market Square.
Okay, so your wife was having her oil changed when her mother got sick, and your wife needed to go to the hospital. And since you're not able to go over there, she dropped you off downtown to catch the bus to go home, right? And
yes, sir.
You took it on yourself to go get some takeout, to get some food, and you provided the receipt to Ms. Romo. Is that right?
Yes, sir.
And how many other violation reports have you had?
None.
Okay, Judge, that's all.
I just have a follow-up question. Okay, so Mr. Espinosa, you're aware that the court receives the records from your ankle monitor, right? You're aware of that?
Yes.
Okay, so what you're telling this court is that you sat at the bus stop at Take 5 Oil from 1:58 p.m. to 2:56 p.m. For 1 hour, you sat at the bus stop.
I was at the bus stop, next to that bus stop, and next that Take 5 Oil because I could not go inside that Take 5. And I'm aware that I couldn't go in there, but I was still there. And I
Okay.
waited for her to finish.
Okay, and then you're also telling the court that your to-go order in Market Square took from 3:46 p.m. to 5:19 p.m. to be prepared.
And when I went in there, ma'am, I had to wait for me to get an order. So basically, after I got my order, I still had to wait for them to give me my order. And I
Okay, so
did
that's what I'm
provide her.
asking you. That's what I'm asking you, because that's what the record says, that you were in there from 3:46 p.m. to 5:19 p.m. So what I'm asking you is that how long it took for you to get your to-go order from there? Yes or no?
Yes, yes, ma'am.
Okay. We pass the witness.
All right, any further questions?
No, Judge, I would just request that Mr. Espinosa be allowed to rent a U-Haul to conduct the moving of the things in storage. And since he's off on this Saturday and Sunday, he could use the whole day, Saturday and Sunday, and move most of the things out of there, he says. So that's all we're asking for, Judge.
All right, State, do you agree to any of this?
No, Judge, given the non-compliance, Judge, he was placed on the ankle monitor for community safety and assurance of the no contact order. And given the non-compliance, I mean, they're saying that he's allowed to get to-go food. That's news to me, because I've never heard of that being the case on GPS monitor. So he's already been given, partial to attend Ross, DD Clothes, Pika Pika Plaza. And so if the court is entertaining the idea of allowing him to do this, I would ask that it would just be for 1 day.
Oh. So I'll allow him to move 1 day. So do you want Saturday or Sunday?
I guess Saturday, Your Honor.
All right, so do you want this Saturday or next Saturday? I don't know how long it will take you to.
I guess whatever I can move, Your Honor.
No, I mean, do you want it this Saturday or do you want it a different Saturday? You tell me what Saturday you would like.
This Saturday, ma'am. This Saturday.
All right, so that'll be Saturday, August 1st. And what time are you going to start moving?
As early as I can, ma'am.
No, I mean, you tell me.
I would say it's 7 a.m. till they close. The inn closes at 10 o'clock. So, I mean, that's the latest that I mean, I can do anything.
All right. I'll give you 7 a.m. to 10 p.m. and counsel, you need to provide the state with the address that he is moving from and the address that he's going to be residing.
I have done that, Your Honor. And just to clarify, he can go to get the U-Haul truck, right?
Yes.
Okay, and
I
when?
don't think they deliver U-Haul. So I'm allowing him to move from 7 a.m. to 10 p.m. I will allow him to pick up the U-Haul and return the U-Haul.
Okay, very good, Judge, because usually on Sundays, it's my experience with U-Haul that they're closed on Sundays.
Oh, no. He's doing Saturday.
No, but he's going to rent U-Haul he's going to be moving until 10 p.m. By that time, the rental place is closed, and he cannot return it at 10 p.m. on Saturday, and he cannot return it on Sunday either because the office is closed. So I'm just asking for permission for him to return it. I don't know, maybe he can make some special arrangement with them.
All right, well, he will need permission from the court if he is going to do that. But for now, he can pick up the U-Haul at 7 a.m. He has the court's permission to return it before 10 p.m. on Saturday. And if he wants to return it outside those hours, he will need to come back and obtain permission from the court or from pretrial services.
Uh,
Sir, you're going to need to provide where you will be picking up the U-Haul from and where you will be returning it to pretrial services so they will have it. And you will need to provide the location of the home that you're moving from and moving to. And this is what I'm going to tell you. I'll allow you to stop for gas. I think you're going to have to stop for gas, but all the other stops you're not going to be able to do. You understand?
I understand, Your Honor.
All right. And so that'll be on Saturday, August 1st from 7 a.m. to 10 p.m. Who's your pretrial services officer?
Or Jasmine Romo.
All right. Norma, can you see if Jasmine can zoom in, the pretrial officer?
Yeah.
All right, just stay on Zoom. We're going to see if they can zoom in.
Romo. Judge, and I guess the other thing that was not broached by counsel, but it's in his motion on the order part is I presume that they were going to be asking for the defendant to be allowed to go to Trader Village to buy necessary lawn care tools.
No.
Okay, because we're not in agreement with that.
No,
Judge, I did not put that in my motion. Mr. Espinosa runs a lawn care business, but he has some people that are doing it for him right now. He was just asking me for permission to go to Trader Village to buy some lawn care equipment. And I started talking with a prosecutor about that, but she's not in agreement with that. So this is not timely for me to address that or try to argue that in court. So we can leave that for another day, Judge. But I'm still going back to this rental. I'm kind of confused because he cannot, you said he needs to get a court order to return that rental vehicle.
No, what I said was, I am giving him Saturday, pick up the U-Haul 7 a.m. And if he wants to keep the U-Haul all of Saturday, he can do that. But I'm just only giving him time from 7 a.m. to 10 p.m. to move and return the rental truck. If he doesn't make it within that 10 p.m. rental to return that U-Haul, then he's going to have to do it on another day, and he'll have to get permission from the court to do that.
So he'll have to keep it rented. I file a motion during the weekend and have it heard on Zoom Monday morning then?
Yes.
I'm just trying to clarify this for my client. Okay.
All right. So if you all give me a moment, I'm going to put you all I'll put you all in the breakout room so you all can talk. And then I will bring you back in once the pretrial services officer has zoomed in.
Thank you, Judge.
You're welcome. Officer Romo?
Yes, Your Honor, I'm here.
Hi. So we are here on Mr. Romero. It's cause for 2026 CR 005225.
Okay, let me just pull him up really quick because I was doing an orientation, so his profile is loading really quick.
I'm so sorry.
No, that's okay. No worries. It's just still loading. Give me 1 second. System's still going slow.
Oh, it's always the way.
All day.
Yes.
Okay, perfect. It uploaded. So you said for the 2-5, correct?
Yes.
Okay.
All right. So this is what's happening with this case. Defense filed a motion to allow the defendant to move from one home to another home. So I'm allowing that, but it's only going to be on Saturday, August 1st. And it's going to be from 7 a.m. to 10 p.m. And the defendant is going to be making 3 stops. Well, really 4 stops. He's going to make a stop to pick up the U-Haul. He's going to provide that address to you.
Okay.
Then from picking up the U-Haul, he's going to make a stop to the location that he is packing up. And then from there, he's going to provide you the stop to the home that he's moving into. And then his fourth stop is going to be back to return the truck to the U-Haul. Now, he will be allowed to stop at gas stations if that is needed.
Yes, he already has that approval as well for any errands that he runs. He is allowed drive-through, and if he needs to get gas, he has been submitting receipts for those. So he's aware that with any errands that he runs, he automatically has those included.
All right, so it's on Saturday, August 1st from 7 a.m. to 10 p.m. I'm going to a breakout room so he can provide you with the information.
Okay, perfect.
All right, so I'm going to move you all to breakout room number 1.
Okay, thank you.
All right, thank you so much for zooming in on such short notice.
No, that's okay. Thank you so much. You have a good day, Your Honor.
All right, you too.
Bye-bye.
Bye-bye.
You're on 3 from the bottom.
All right, thank you. Nanjalik Duran. All right, where are we on this case?
Discovery is complete, Judge. We've tendered offer. It's been rejected. It does state trial date today. So if we were to pick jury and proceed tomorrow, state does have a continuance because by some chance, every witness we were to call is unavailable.
All right, so what I can tell you is we can't do a jury trial today. All the jurors are gone. What I can do is I can recall this for the week of the 17th or the week of the 20th for a jury trial.
Either of those work, Judge. We just need a date after August 4th.
All right, Norma and State Defense, if you all confer on a jury trial date, and let me know.
Yeah. For the record, Your Honor, well, we didn't get to that point, but I was going to be opposed to that motion.
All right, let's go on the record. Let me see. I mean, the thing about it is, though, I can't do a jury. Here's what's going on, and we'll go on the record. Court is calling 2026 CR 004773, State versus Nanjalik Duran. Can I have the parties announced?
Lauren Espinoza for the state.
Martin Garrett, attorney for Angelique Duran.
And are you Nanjalik Duran? All right, the state has filed a motion for continuance. I can rule on this motion. However, there are no more jurors available downstairs. And then on Friday, jurors are not called up, so we won't have any jurors on Friday. So if there were to be a jury selection in this case, the earliest would be August 3rd.
To which I would say the forensic tying test is not back until August 4th. So I would still ask for a date after.
Yes. So
the 7th.
Then it would be August 4th for a selection and then testimony on Wednesday. Because you're saying they're not back till August 4th?
The scientist, but then one of the officers doesn't come back till the 7th.
So I can do the week of the 10th?
We'll ask for the earliest possible date, Your Honor.
Okay. All right, Norma, if you'll put this on August 10th. And I'm sorry, Mr. Wrong, we just don't have any jurors this late in the day. Okay. And people will tell you, I'm always ready for a trial. Anybody wants one, we will have one. Oh, and could you all do an acknowledgement of discovery for me?
Yes.
Thank you. All right, Mr. Thompson,
Yes, Your Honor.
does he wish to have a new attorney or?
Yes, Your Honor.
All right, Mr. Thompson. Mr. Guerra will be appointed to represent you. And counsel, of course, I'll give you time because I know you need to look at discovery and everything.
Yes, Your
Honor. Do you want it brought back as the same time as the other case or you want more time?
More time. He resides in Austin.
Okay. All right, then let's recall this for the end of August.
Can we make it in September?
No, I mean, he can appear by Zoom.
Oh, okay. Okay. Oh, Zoom? Oh.
Yes. But here's the thing, when people appear by Zoom, you have to be dressed appropriately and you still need to be on time.
Yeah, I'm getting Zoom.
Okay.
Most of my Zoom.
All right, so what date, Ms. Ferguson?
September 1st.
No, I said the end of August. He's gonna be by Zoom. So do you have an August date for him?
August 31st.
All right, August 31st.
31st.
All right, we'll see you then.